Autumn Kiefer attempted to prepare a pre-sentence report in this case, but the defendant was very reticent to provide much information. So her report is somewhat abbreviated. Not sure if she's back yet. She's been on vacation. All right, it's 10:37. We're close enough to on time. This is the sentencing in a matter of People versus Brandon Bartell Schoolcraft. File number is 24649SM. Mr. Schoolcraft was charged with aggravated domestic assault, and the matter was tried as a bench trial before this court earlier this late summer. The defendant was found guilty by the court, and the matter was set for sentencing today. The court had requested a pre-sentence investigation because still had a lot of unknown quantities here. Attorney James Mequio, Special Assistant Prosecuting Attorney for St. Joseph County, is present with us on the Zoom feed. Mr. Mequio tried this case on behalf of the prosecution. John Bush represented the defendant at the trial. Since then, the defendant has retained attorney Anastasi Marcu, who is here with us in court this morning. Also present is Autumn Kiefer, who attempted to do a pre-sentence report, got only so far, and our complainant, Leslie Schoolcraft, is present, and the victim advocate from the prosecutor's office is present. As I indicated, even though I heard this case at trial, I still had a lot of unanswered questions about the defendant and this whole circumstance. So I asked for the pre-sentence. The defendant had retained Mr. Marcu, and there was discussion of an appeal or something. So he was reticent to provide much information. So good morning, Mr. Marcu. I'll start with you.
Good morning, Your Honor.
What's your position here?
Your Honor, is the court asking for allocution or is the court?
Yeah, no, allocution.
Thank you, Your Honor. So, the court and Mr. Mequio understand, I advised Mr. Schoolcraft not to speak at all about the substance of the offense. I did not advise him not to speak about his personal background or anything like that. But because he has a fundamental right to appeal a case if he chooses to do so, that was my safe recommendation to him to make sure that he preserved any rights that he might have had. Regarding any possible sentencing in this case, this court knows that I was not present for the trial, so I cannot speak about the facts that were elicited at trial. However, as to Mr. Schoolcraft himself, the court can see that while he did have a criminal history when he was younger, the last substantive offense would have been in 2009. That's now 15 years ago that he had any sort of either felony or misdemeanor behavior. That's a long time in which he has demonstrated a change in his behavior. All the other criminal offenses all occurred before his age of 24 when he was a young man, probably doing things that he shouldn't have been doing. Some of them were actually when he was a teenager. So I would ask the court to consider that because his last offense is at least 15 years ago, that the court consider that in fashioning any type of sentence. Mr. Schoolcraft has also been employed 11 years. Any type of substantial incarceration would most likely result in him losing his job. While he could take some personal leave, I don't think there would be enough personal leave available for a 93-day jail sentence for him to be able to maintain his job. Having a job for 11 years is a substantial positive. This court can weigh that against what the court heard at trial to decide how that affects the court's sentencing in this. What I'm asking the court to do is to consider instead a short jail sentence, 14 days or less, with a term of probation of 1 year, to make sure that he is complying with the law. If any domestic violence counseling is recommended, I know he'll do everything that he's supposed to do. The court can see that even when he was young, he was able to at least on at least one occasion be able to successfully complete his probation. Now that he's a mature adult, He knows what his responsibilities are. If the court tells him to be somewhere, he'll do it. If the court tells him to do an assessment, he'll do it. If the court tells him to complete counseling, he'll do it. He'll do whatever the court tells him to do. So my main 2 points are, he's been crime-free for 15 years. He's been able to be a contributing member of society for that time period. He's had a great job for 11 years. I just don't want him to lose that, Your Honor, and that's what I'd ask the court to consider.
Thank you. Mr. McWheel, before we hear from you, I'd like to hear from the defendant, and then I'd like to hear from the complainant, and I'll give you a chance to speak. Mr. Schoolcraft, what do you want to tell me, if anything?
I really don't know. I'm just, there's so much stuff that you didn't hear. I don't know. I'm just trying to,
Let me ask you a couple of questions. You're still at a,
yes,
what shift are you on?
second.
Where are you living?
Currently I'm living in my truck. I am staying, like, sometimes I can stay like my aunts or friends and things like that, but mostly I'm in my truck.
Where's your aunts?
3 Rivers.
Are you contributing to the family expenses?
What do you mean?
Your house payment, food for your kids, light, heat bill, that sort of thing?
I mean, I'm paying $403 a week in child support.
All right, so there's a child support order in effect.
Yes.
When did that take place?
I believe in July.
But you're not yet divorced, correct?
No.
All right, so there's an interim support order.
Yes.
All right, well, that's something. Are you working overtime?
When I can. It just depends. Some weeks I can get Saturday, Sunday. Some days I can stay over. Just sits up and down.
So you take all the overtime you can get?
Yeah.
All right, Ms. Schoolcraft, would you come forward, please? Thank you. You're Leslie Schoolcraft?
I'm Leslie Ann.
Yes, you told me that, and I apologize. I
That's
forgot.
okay.
Let me change that. You were here at the trial, and I heard your version, and I heard your version, and I believed yours. I believed Leslie's version over Brandon's version, which essentially means I didn't believe Brandon was telling me the truth about what happened. As Mr. Marcoux indicated, he's working at $403 a week in support. You got kids with special needs. I don't know, frankly, how you do it. You're working, you've got children that need extra help. I don't know, there are enough hours in the day to do everything you do and sleep. But it used to be for both of you. Now you're carrying most of that burden yourself. What would you like me to know?
I did write a statement.
All right.
Your Honor, I would like to address the courts today because speaking to Brandon won't matter to him. Honestly, he doesn't care. I've tried many times since trial and he has never taken accountability for assaulting me since it has happened. He's shown zero remorse. He's never felt bad for what he's done. He's upset that I stood up to him and stopped allowing him to hurt me for the first time. After he attacked me that day, he ran from our home. He showed up the next day for his belongings. I gave him even more money, packed all of his belongings in his truck before he arrived, gave him a hug while he was completely disrespectful to me in front of the officers. He then left out of state for 4 days. He had no contact with me and his disabled children. He did not check to see if the kids were okay after having to witness their mother be attacked. He never asked if I was okay or needed medical treatment. He just moved on with his life and has told everybody lies about what has happened. He has sat here during trial and he never looked up for him from his phone while he was texting.
What unfolded in this St. Joseph County courtroom was more than a sentencing hearing. It was a window into the quiet devastation that domestic violence leaves behind long after the bruises fade. Brandon Schoolcraft stood convicted of aggravated domestic assault following a bench trial. The evidence was damning. The judge believed the victim. The defendant offered little. No remorse, no accountability, no real explanation. Just silence and legal strategy. But the most powerful voice in that courtroom belonged to Leslie Ann Schoolcraft. A woman raising 2 autistic children alone. A woman who lost a daughter in a fiery crash in 2020 and still tends that roadside memorial every single night. A woman who was knocked unconscious, had a tooth broken, and yet stood before the court and said, "I don't want him to suffer. I just want him to be a father." That kind of grace under that kind of pain is almost incomprehensible. The judge wasn't moved to leniency, but he was moved to balance. Schoolcraft received 24 months of probation, 93 days in jail with 78 deferred, served on weekends. He's ordered into the full domestic violence treatment program, substance abuse evaluation, and mandatory drug and alcohol testing. No marijuana, no edibles, no exceptions. The judge made it plain: complete the program, stay clean, and maybe, just maybe, a family court judge will see a man worth trusting with his kids again. The road back won't be easy. The road Leslie has already walked was harder. Justice here wasn't loud, but it showed up. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.